Ms. Broussard, are you aware that your son in the last 5 years has been arrested for 9 different offenses?
Excuse me?
Are you aware that in the last 5 years your son has been arrested for 9 separate offenses?
9?
Yes, ma'am.
Jonah Johnson, 25 DCCR 1775.
John.
It's not going to take much for me today to lose my. I'm right on the verge. I am at my word limit.
Good morning, Your Honor.
Good morning.
I have one witness in this case. Your Honor.
Good morning. Are you Jonah Ray Johnson?
Yes, Mom.
And this is 25 DCCR 1775. Mr. Johnson is charged with aggravated assault with a deadly weapon. And Mr. Vasquez has filed a motion asking that I reduce Mr. Johnson's bond, which is currently set at $300,000 in that case. Are you calling your client?
Yes, Your Honor.
Mr. Johnson, best you can, raise your right
Oh,
hand.
no, I'm sorry, Your Honor. I'm not. I'm calling my client's mom, Jacqueline Broussard.
Ms. Broussard? Mr. Johnson, if you'll just come around just to the side, right there on the corner. Ma'am, if you'll come right over here, please. Good morning. And would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may proceed.
Thank you, Your Honor. Ms. Broussard, state your name for the record, please.
Jacqueline Broussard.
And you've done this before, haven't you?
Yes, ma'am. Oh, sir, I'm sorry.
And you are Jonna's mom, correct?
Yes.
And the original bond back in September was $150,000. Wasn't that correct?
Yes, sir.
And what went wrong? What was the problem there?
The ankle monitor. We thought it was broken, which we was led. That was, we called Johnny, and Johnny told us to come in, which we had been talking with Johnny for 2 weeks. But like I say, Johnny said come in, and something's going on with the monitor. And we also was a payment behind.
Okay.
But we like.
let me interrupt.
I'm sorry. Go ahead.
That's all right. The bondsman said the defendant has failed to pay for the GPS device. It wasn't charged. He will not respond to surety's attempt to reach him. He cannot be located.
The discussion then focuses on whether there was any realistic chance that he would leave the area or avoid future court proceedings. The witness answers with complete confidence and states that she has no concern whatsoever that he would run away. She also makes it clear that she would never spend a large amount of money on a bond if she believed there was any chance he would disappear. The conversation then moves toward earlier contacts with bonding companies. The witness explains that she had spoken with several agents over time and remained in communication regarding possible bond arrangements. She tells the court that those discussions mainly centered on waiting for a decision about whether the bond amount could be lowered. A recent message from one of the agents showed that they were still prepared to assist if circumstances changed. When asked what amount might be manageable, the witness explains that previous conversations had focused on a figure of $100,000. The court quickly notes that the bond had previously been set at $150,000 and suggests that a reduction to the lower figure may not be realistic under the current circumstances. As the exchange continues, the witness clarifies that she is asking the court to return to the earlier amount rather than seek a larger reduction. She confirms that restoring the previous $150,000 bond would be something her family could work with, and that such a decision would provide a path forward while the case continues through the legal process. The hearing then shifts toward a closer look at the defendant's home life and personal stability. The witness firmly rejects any suggestion that the bond was ever in danger and makes it clear that there was never a concern about losing that financial commitment. As questioning continues, the court learns that Jana has been living in the same residence with her husband and 2 sons for more than 5 years. The testimony paints a picture of a steady household where all 4 family members have remained together for a long period of time. Attention then turns to Jonathan and his situation before the arrest. The witness explains that he was employed at a local workplace where he spent his time working in the kitchen. According to the testimony, he had secured that position only a few months earlier and had been building a routine through regular employment. The court also hears that he was 18 years old and continued to live at home with his family, which further highlighted his local ties and daily responsibilities.
Yes, sir.
I think 10%
Yeah,
is the one.
yes, sir.
Would you make sure there was no discrepancies or mistakes or misunderstandings about the GPS monitor system?
Yes, sir.
And what else would you like to tell the judge? About the bond.
I'm not the one. We are ready, prepared to make fun.
Have you seen the video in this case?
Yes, ma'am.
Okay.
I have talked to my son. Yes, ma'am.
You've actually
And-
seen it?
Yes, ma'am.
Okay.
The whole video.
Okay. Anything else?
Nothing else, right?
That was
Questions of
actually,
this
that was
witness?
actually one of my questions I was going to ask this witness is whether or not she's seen the video, Judge.
Okay.
In addition to that, Ms. Broussard, are you aware that your son in the last 5 years has been arrested for 9 different offenses?
Excuse me?
Are you aware that in the last 5 years your son has been arrested for 9 separate offenses?
9?
Yes, ma'am. Evading arrest as a juvenile, UUMV as an adult, possession of a controlled substance, unlawful carry of a firearm, failed to ID, possession of a controlled substance, possession of marijuana, and 2 additional unauthorized carrying of a weapon. Were you aware of those arrests?
Yes.
Okay. Now, the gun that your son allegedly carried back on August the 31st of 2025, during that shootout at the Pine Club Apartments, do you have any idea where you got that gun from?
No, sir.
Are you aware that a bystander was shot during that melee?
Yes, sir.
All right, that's all I have, Judge.
Okay. Any other questions of this witness?
No.
Thank you, ma'am. You can have a seat.
Thank you, no.
Excuse me.
Any other witnesses, Mr. Vasquez?
No, Your Honor.
Mr. Coleman?
Judge, one of the items of evidence that I plan on introducing was the video from the shootout. It sounds like the court vividly remembers that. So if the court doesn't wish to see that again, I want to.
Let's just quickly play it. I want to, I'm refreshing my memory by taking, well, first of all, I'm going to take judicial notice of the court's file. I have reviewed the probable cause affidavit, which is what reminded me of the facts of the case. And I guess it was the other
It was the
case that
co-defendant.
we had a bond hearing on. Is that
Yeah.
correct?
Well, no, I take it back. It was this defendant when he was represented by Brittany Holmes, if I'm not mistaken.
So I've had a bond hearing, watched the video on this case.
Yes, Judge, if I'm not mistaken. In fact, when you look at my notes, yeah, that would have been January 13th of 2026. My notes include that there was a defense motion to reduce the bond. We argued, you heard evidence and testimony, and that you denied the motion back in January of this year.
So this was after the AFRS, and the bond was at 300,000 on that date for the same bond hearing.
Yes, Judge.
Your motion's denied. I've already heard all the evidence.
There is something, Judge. I think that it's at least, if you're going to deny it, I think you may want to consider it as far as whether or not the bond is sufficient. As it states, it's just a 5-minute clip of
Go ahead.
a jail phone call that I've added subtitles to. If I could do that, I'm happy to bring my sponsored witness. But if you'll stipulate to it,
No, I'm going to object to it to relevance. Your Honor.
Bring your witness, please.
Yeah. State calls Captain Michael Palmer.
Good morning, sir.
Morning, Mr.
Thank you for your patience this morning. If you'll please raise your right hand, do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, sir. Go ahead.
Captain Ponder, would you state your full name for the record, please?
My name is Captain Michael Ponder.
And Captain Ponder, very briefly, what do you do? What are your duties at the jail, over at the jail? That's your department.
I'm the custodian of records for the Jefferson County Correctional Facility.
And you're familiar as your custodian of record with the recording equipment there at the jail, correct?
Yes, sir.
And it's capable of making an accurate recording.
Yes, sir.
Each inmate is issued a unique identifying number, correct?
Yes, sir.
And that's one of the ways to identify who makes certain calls from the jail, correct?
Yes, sir.
Have you had an opportunity to review where I am marking? Judge, you want me to mark this as states 2 or 3? We entered one in the first hearing back in January. I can do it 1. However you want to do it.
I think, it's technically a new hearing.
Okay, I'll do 1. Okay.
One's fine.
All right. You recognize this USB drive?
Yes, sir.
How do you recognize it?
Because I listened to it this morning.
And are these your initials in today's date that's on this USB drive?
Yes, sir.
I'm marking it as State's Exhibit number 1. You listened to it. Do you have any doubt that it's a fair and accurate copy of a jail phone call or recording of a telephone call made by an inmate, this inmate, from the Jefferson County Jail?
No, sir. No doubt.
All right, Judge, state off state. Statesman.
Mr. Vasquez?
Good morning.
Yes, sir.
How long is this video?
This is
the
an audio.
recording,
I'm sorry, the audio.
It's about a 5-minute excerpt from a 14-minute and 20-some-odd second phone call.
Well, so it's been altered.
It's been included, yes.
I object to the alteration, Your Honor.
Judge, what's on here is the original 14-minute long video as well as the shortened 5-minute video with the subtitles added. So the original's on here.
Okay.
And by the way, I gave it to Mr. Vasquez yesterday, and he's had a chance to preview it.
States 1, with both, will be admitted.
Permission to post, Judge?
Yes.
Judge, if I finish my objection, Judge,
Sure.
I object to the alteration, and then there's a transcription. I object to that as hearsay, where you give
The subtitles.
the subtitles of what you think they're saying.
Do you disagree that the subtitles are correct with what you hear?
I don't know, Your Honor. I just object to it being hearsay.
How is it hearsay?
The subtitles are on it to what it's someone has written in what they've transcribed the conversation to be. I object to that as hearsay.
Mr. Coleman?
Judge, if the audio is not hearsay, which is a statement made by a party opponent, then the subtitles are therefore not hearsay. Judge, it's just,
Obviously, we'll be able to listen myself, and your objection's overruled. It's admitted.
permission to publish. Judge.
Yes, and that's both the excerpt as well as the entire. And thank you, Captain Ponder.
Yes, sir.
Recorded or monitored.
nigga went crazy for me. Wow. No, he said people screaming that shit. They say, man, world star type of shit. Bro, all over the world. But a couple days later, man, first it was cool, we was chill. Kept like, bitch, you good, you good, you sure you good, bitch, and they good. Like, I'm good with the whoop. So one day, he just snapped. CO said something to him. And I said, what, bitch, ass, what the play? So I get to the CO, like, they want to punch you. They gonna say, come on, like, I'm 60 weeks. Whoop. Nigga, so he ain't trying to CO, ain't trying to punch, like, boom, he smacked the motherfucking computer, punched that bitch. Break the motherfucking computer. They come, he been in the end door, ever since they came out, I thought he been in the end door. That bitch 25, so it was trick, so good. Hey, you ain't, bitch. Anyway, you gotta do at least one, yeah. You gotta hit that. If you go down that trip, he gonna put it up for college for five. Yeah. And they go, it's his whole point. That's my little folks. Look at that first time about, you wanna leave your sentencing to the judge? And I said, hell nah. Take my shit to trial. I said, they're going out my bus for the government. I seen all my evidence and shit. That shit bullshit, bro. Let me take this to trial, bro. They gonna drop the charge. So I told take the trial. Ooh, my lawyer's good. I need to look at the paperwork and shit. Like, oh, you good? You fit? You give it some time. Like, I know it's gonna take time. Because everything that's going on right now, they ain't making it no better. My shit, but like I say, they come, even if they come like this, 5-year cap, they gonna send they off probation with a 5-year cap. I take that. I want to be careful. I want it 5 years. But if they do, I put like 2.5 on that bitch. Oh, come on, for a bank, you gonna have some bank time. Get fed. I'm gonna have some bank time. Sorry, I got 5 months bank time right now. You get that 5 months, 5 months, bitch. Damn. But it's like 5 months. Too much I did, boy. This shit look like shit over. Very good point of the phone, because I think when I really kind of been flying by. It is like, once you get in, it's going to just flying by. Wow. Sure. This shit. Very vicious. So, man. Wow. This is something. I ain't in the mug, but this shit. Very big. Something. And cause they've been around young niggas be so hard to do it. I stay out the way. But you know, push gonna come to shove, some shit gonna happen. Boom, you know. Get to the like that was my first write up. Like bitch, I've been chilling, so I've been quiet, doing that to nobody. That there's just write up, got another write up, I got fighting write up, other fight or something. But I think they moved to this door. Shit. It was check out to the top. So I do put me on games that know what's going on. Like, shit, so I guess it was my first came in, so I was a KO, boom. I said, it's coming to hell, leave and go back. You know, there's gonna be a lot of niggas like this, I'm good. I'm like, man, I can't back to this, right? So when I'm like, yeah, oh, they can get out this whole like, fuck, you see this, you know. I ain't gonna figure the world like this. It has to be good. And I also, shit, say, give a nigga probation for worse shit like that. Good. This how I move. You come out on top with position probation for what you get. They just gave my other part, my free world part, they had 3 robberies. They gave nigga, ISL for 3 months and 10-year probation. That's like that nigga, you can't even believe. That's what I'm talking about. They gave ISL 3 months. He got 3 months ISL. He got 10 years probation. After he was already on probation for 10 years. But crazy, even the dude that got fight with the court the same day. You know.
That's all I have on that, Judge. State has no further witnesses.
All right, anything else?
No, Your Honor.
Okay. So at this time, I am going to deny the motion for a bond reduction. And I guess, Mr. Coleman, depending on any future incidents, if the state wishes to file a motion to increase, I would look at that at the appropriate time.
We have contemplated that, Judge.
But Mr. Johnson, a condition still, if you make that $300,000 bond, is that you would be on house arrest. You would be required to wear a GPS monitoring device at all times. Part of the reason that I'm doing this is because it sounds like you were working, your parents have the issues. I've looked at the bond, the affidavit for them to release surety. It's not just the GPS monitoring device. They obviously were having a hard time getting in touch with you for whatever reason. So I think that makes obviously one of the criteria under 17.15 for bail is that obviously you have to follow all of the rules and conditions of bond, which is with your bondsman as well. And so we will reset your case for an announcement, and Mr. Vasquez will visit with Mr. Coleman, get any offers in your case, and we'll either take a plea if you wish to take a plea at the next court date, or if you don't, we'll do a rejection and get your case set for trial. All right.